सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां.
With that soulful rendition, I now have the honor of inviting Dr. S. Vaidi Subramaniam, the esteemed Vice Chancellor of Sastra Deemed University, to deliver the welcome address.
Distinguished orator for the 19th Nani Palkhivala Memorial Lecture, Justice Shri Ramasubramaniam, the chairperson of the National Human Rights Commission, the Dean School of Law, Dr. Balasubramaniam, student friends, my faculty colleagues from different disciplines, friends from the print and the electronic media, a very good afternoon to all of you. Today we meet here for the 19th Nani Palkhivala Memorial Lecture. And I see a converging triad of sorts, which makes it very special. The first being the person in whose honor that this event is conducted every year. The second, the person who is delivering the Nani Palkhivala Memorial Lecture. And thirdly, the topic on which he is going to speak. So these three converging dimensions, I'm sure, is not only a reason to celebrate, but also celebrate because of the contemporary relevance of the topic that the speaker has chosen. On the eminent jurist in whose honor that we are organizing this talk, I am only a dwarf before his unseen presence in this campus ever since we started organizing this annual lecture in 2004. At that time, we did not have a law school, but the person who shaped the minds of different generations at that point of time was so influential that as a responsible higher education institution, we felt that successive generations need to understand the significant role that Nani Palkhivala played in the constitutional evolution that happened in our country. And not only that, just last month, we successfully conducted the 10th Nani Palkhivala tax moot court competition at Shastra, which came from GLC Mumbai in 2015 to Shastra thanks to the Nani Palkhivala Trust. So both these events have been flagship events for our law school, constantly igniting young minds to look at such towering personalities as career inspiration as you graduate from this law school. The second dimension, the speaker for this afternoon session. Again, for the faculty, you may please be seated. For the faculty, not a new face, a familiar face, because we fondly recall your lordship's speech that you delivered here around 10 years back on the legal jurisprudence of Kamba Ramayana, which today even has a lot of visitors because it is still on YouTube, and many visit that wonderful lecture you gave in this very same hall 10 years back. After which, that was when you were the judge of the High Court of Madras, after which you were elevated to different positions. And after your spectacular term at the Supreme Court, it is our proud privilege to welcome you again as the chairperson of the National Human Rights Commission. So please put your hands together and welcome Justice Sri Ramasubramaniam, for this 19th memorial lecture. The third is on the topic that the Lordship himself chose to address this young audience. In fact, to be honest, I had requested the Lordship to address on AI in law, but I think he has chosen a better topic because I feel that this topic is also getting very contemporaneously relevant, given the fact that science and technology is altering not only the engineering or science or technological developments, but also in the legal profession, there is a lot that is happening that is deeply influenced by science and technology, and more particularly seen from the realm of how it is influencing human rights. There might be certain parameters that directly influence, certain that indirectly influence, certain that appear to influence but not influence, certain factors that appear not to influence but very deeply influence human rights. So there is a multi-dimensional perspective on how science and technology will impact human rights. And I think the time now is appropriate for graduates, would-be graduates rather, like you, who will be joining the profession very soon, and also for academics like us to also to understand how science and technology will not only affect human rights, but in the process also change the contours of jurisprudence, because the contours of jurisprudence are also continuously getting reshaped by these sudden developments that take the profession by surprise. So friends, that's why I said this converging triad makes this event very special for us. And it is my privilege to welcome again Justice Ramasubramaniam and this wonderful audience here for the 19th Nani Palkhivala Memorial Lecture on behalf of the management, faculty, and students, and on my personal behalf this evening to Shastra. Thank you.
Thank you, sir, for setting the tone for this evening and enlightening us about the illustrious topic that has been chosen for today's lecture. As they say, gratitude is the memory of the heart. I now request the Dean of the School of Law, Dr. A. Balasubramanian, to present a memento as a token of gratitude. And now, the moment we have all been waiting for. It is our distinct honor to welcome the chief guest for this year's lecture, Honorable Justice Sri V. Ramasubramanian, Chairperson of the National Human Rights Commission and former Judge of the Supreme Court. Sir's esteemed legal journey from the Madras Law College to the Supreme Court and now the National Human Rights Commission continues to inspire legal professionals and students alike. Sir, we are truly honored by your presence, and I now kindly invite you to deliver the 19th Nani Palkhivala Memorial Lecture.
கனெக்ட் ஆகிக்குமா அங்கேருந்து பண்ணுறதும் பண்ண முடியுங்க அங்கேருந்து பண்ண முடியுமா ஓகே பண்ணிக்கிறேன் ஓகே நான் சொல்லும் போது வந்தா போறேன் இப்போ வேண்டியது இல்லை I call you. My good friend, Dr. Vaidya Subramaniam, the Dean of the School of Law, Mr. Balasubramaniam, my dear faculty members, students. I think there are too many Subramaniams on the dais. In fact, the Kanchi seer once said that what is so special about Subramanya is that Subramanya's name alone is repeated thrice in the Vedas. Subramanyogam, Subramanyogam, Subramanyogam. As ardent followers of the Kanchi Mutt, perhaps Dr. Vaidya Subramanyam made it a point to have Vaidya Subramanyam, Bala Subramanyam, and Ram Subramanyam on the dais. The topic that is chosen for today's lecture, as all of you know, is science, technology, and human rights. The impact of science on our lives was summarized in a very interesting way by someone in the social media, an anonymous author. It goes as follows. Today, because of science, our communications are wireless, our phones are cordless, our cooking is fireless, our food nutritionless, our sweets are sugarless, our labor effortless, our relations thankless, our attitude careless, our feelings are heartless, our politics shameless, our education valueless, our mistakes are countless, our arguments are baseless, our youth jobless, our needs are endless, our jobs are commitmentless, our bosses brainless, our salaries less and less, and our situation hopeless. This is how they summarized the impact of science and technology on our lives. While science and technology has increased the longevity and improved the quality of our lives, they have also rewired our philosophy of what is right and what is wrong. This has led to two things, namely, one, the creation or identification of new and new human rights, and number two, posing challenges to the existing rights. Similarly, the developments in science also changes our attitude towards several things connected to human rights. Therefore, I will divide my lecture into three parts. The first part dealing with the impact of science on the system of administration of criminal justice. The second part dealing with how the developments in science and technology have created new human rights. And the third part dealing with how certain developments in science and technology have adversely affected even the existing human rights. Let me now go to the first part. The Constitution advocates a scientific temperament. Article 51 capital A, clause H of the Constitution imposes a duty upon every citizen to develop scientific temper, humanism, and the spirit of inquiry and reform. This is part of the fundamental duties. Does a scientific temperament in criminal cases help courts resolving problems? I will now ask you a question. In the meantime, the formula can be screen shared. Mr. I think Sriram can screen share the formula. I will ask you, how many of you think that a scientific temperament will help solve criminal cases? A scientific approach, how many of you think so? A scientific approach? No one thinks. Because science has nothing to do with law? That's what you think? Oh, the response is very poor. All right. Let me begin by showing something very interesting. It's a mathematical formula. Just display the mathematical formula. I think our technology has today not helped us very well. All right. There is a formula. That formula is S is equal to A into minus W plus A first into minus W plus H violence W plus V edu W plus HNCW. Does anyone understand this formula? What this formula indicates? Yeah. Just have a look at the formula. It will not come here. Okay. Okay. Oh, it will not come here. Okay. Okay. Have a look at the formula which is displayed on your left-hand side and the right-hand side. So what does this formula have to do with law or human rights? A company by name North Point in the United States developed a case management and decision support tool. It is called COMPAS, C-O-M-P-A-S. COMPAS is an acronym for Correctional Offender Management Profiling for Alternative Solutions. This tool can be used to assess what is called recidivism. Recidivism is the tendency of a convicted criminal to commit an offense again and again. Recidivist risk is measured by COMPAS on a scale whose formula is what I have quoted. In this formula, S represents violent recidivism risk score. W represents weight multiplier. A represents the current age of the convicted person. A first indicates the age at first arrest of the criminal. Then H violence shows the history of violence. V edu shows vocational education scale. And HNC represents the history of non-compliance. The weight W, that formula, the weight W is determined by the strength of the item's relationship to person offense recidivism that we observed in our study data is what that North Point company said. This explains the formula. But why am I talking about this formula? The reason is that it has something to do with a case. In February 2013, a person by name Eric Loomis was found in La Crosse, Wisconsin, USA, driving a car that had been used for shooting, not shooting pictures, shooting. He was arrested and he pleaded guilty to the charge of attempting to flee a traffic officer. In determining his sentence, the quantum of punishment to be imposed upon this accused, the judge looked at his criminal record as well as the score assigned by this tool compass on the basis of this formula. Compass classified this accused Loomis as having high risk of reoffending. Therefore, the judge sentenced Loomis to 6 years in jail for a simple traffic offense. Now, how many of you will agree? Do you first of all agree that a scientific tool has been employed by the court? How many of you agree that a scientific tool has been employed? How many of you say no scientific tool was employed? I think my formula is not getting connected properly, because when I ask you how many people think that a scientific formula was used, only 4 hands were raised. When I asked you how many think no scientific formula was raised, 5 hands were raised. So 5 plus 4, 9 is not equal to the entire audience sitting here. I think most of you would like not to take a decision. If you don't like to take a decision, I do not know how many of you can really become judges, because judges have to take decisions. What happened was, the accused in this case, Loomis, he appealed this conviction and sentencing on the ground that the trial court, in considering the outcome of an algorithm whose inner workings were secretive and could not be examined, because Compass Company had patented the way the algorithm works. So they will not share the details of how it works. Therefore, the accused, who was sentenced to 6 months, he filed an appeal challenging that the outcome was based upon an algorithm whose inner workings were secretive and could not be examined, and therefore it violated due process. But unfortunately, the Wisconsin State Supreme Court rejected his appeal, and the US Supreme Court refused to grant a writ. Therefore, in the opinion of the US Supreme Court, the conviction and sentencing was based upon a scientific formula. Therefore, they thought they had no reason to interfere. Therefore, days are not far off when human minds will apply scientific tools either to convict a person or to acquit a person or to decide the quantum of punishment to be imposed. And this is the way science and technology have come to impact our human rights, the human rights of either the victims or of the offenders. All of you know that whenever we see from the newspapers that a gang rape takes place, there is a huge public outcry putting huge pressure on the police somehow to book somebody and to provide instant justice, perhaps in the form of encounters. But when our scientific knowledge increases, particularly with reference to neuroscience, all established norms, all established perceptions actually go for a toss. Neuroscience tells us today that even a person who has actually committed a crime may not be guilty for several reasons. For instance, you must have read Section 84 of the old Indian Penal Code, which is perhaps equivalent to Section 22 of the Bharatiya Nyaya Sanhita. According to Section 48 of the Indian Penal Code, which is equivalent to Section 22 of the present code, an offense, nothing is an offense, which is done by a person who, at the time of committing the offense, by reason of unsoundness of mind, he is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Therefore, unsoundness of mind is an exception. But what is unsoundness of mind? Law speaks about unsoundness of mind, but we have to go to science to find out what is unsoundness of mind. What does neuroscience tell us? Keep this section 84 in mind and look at what neuroscience tells us. Helen Thompson is a writer and a science journalist whose book titled Unthinkable. She wrote a book titled Unthinkable. The book created waves. This book contains a real life case study. And this case study goes as follows. In the year 2000, a school teacher by name Luke found himself in a terrible situation. He had developed an increased interest in child pornography. He began acquiring a collection of pornographic magazines. He knew what he was doing was wrong, but he could not control this temptation. He was booked for his pedophilic activities. After trying him, after finding him guilty, the judge gave him two options: either to attend a 12-step program for sex de-addiction or to face jail term. Luke chose the 12-step program but was expelled from the program after he repeatedly tried to molest the nursing staff there. Therefore, he was brought back to court and the judge was about to sentence him for his activities. At the time when he was taken to court, this accused complained of severe headache and he was taken to University of Virginia Hospital. The doctors scanned his head and they found that there was a tumor the size of an egg in the right orbitofrontal lobe, an area towards the very front of the brain. Surgeons removed the tumor, and just like that, Luke's pedophilic tendency also disappeared. After 7 months, he was deemed by the judge to be no risk to the public. He was returned home to his family. But a few years later, Luke's pedophilic urges recurred. This time, he went straight to the hospital. Scan showed that another tumor started developing at the same place. With the removal of this tumor, the second time, his personality once again returned to normalcy. Now, what do you think? Can this case be categorized as one of a person with unsoundness of mind? All of you think it can be categorized unsoundness of mind. Is it unsoundness of mind, or does it have some anatomical problem with the brain? Therefore, it is not really unsoundness of. the confusion that we have about what is brain and what is mind. This leads some of us to think that this case can be categorized as one of unsoundness of mind. Unsoundness of mind is completely different from a pathological sign where a tumor develops in the brain. Law does not make any exception to these categories of persons because they are not considered to be persons of unsoundness of mind. Now, if science, neuroscience can tell us that a tumor in a particular part of your brain can lead to a personality disorder, making you commit a crime, as a judge, what do? Would you convict him for his doing something completely out of control because of his illness? This is a question, this is a challenge that neuroscience has now come to throw upon law and upon human rights. This is why, way back in 1974, the American Bar Association created a section called a section of science and technology to provide a forum for addressing issues at the intersection of law, science, and technology. Simultaneously, they also established what is called National Conference of Lawyers and Scientists. And this NCLS established a joint standing committee comprising of 14 members, half of whom are lawyers and the other half scientists. This forum constantly works in educating lawyers and judges on the impact of law and technology on law. Now let me move to the second part of this lecture. In this part, I will tell you how the developments in science and technology have created a new genre of human rights. If you look at the evolution of human rights, you will find that our journey started first with civil and political rights, which are called first generation rights. From there, we moved on to social, economic, and cultural rights, which are termed as the second generation rights. Thereafter, we moved on to solidarity or collective rights, such as a right to development, right to a healthy environment, etc., which were called as third generation rights. But the advancement of science and technology have led to the creation of fourth generation rights. These fourth generation rights fall under two categories. One is somatic rights, based on the quintessence of personal autonomy and control over one's own body, such as the right to die, the right to change sex, the right to transplant organs, the right to artificial insemination and reproductive rights, the prohibition of cloning, the use of genetic material, as well as other opportunities related to bioethics and medicine, that form one category of fourth generation rights, namely somatic rights. Then the second category of rights under the fourth generation rights are digital or information rights, such as the right to the internet, right to anonymity, right to free access, right to privacy, right to digital personality, right to electronic citizenship, and the right to be forgotten. Right to be forgotten, I think, is inherent in all the students. That is why we don't get the correct answers to correct questions at the time of examination. Without even enforcing it as a right, it comes naturally to us. Let us now see one example of how this fourth generation right was created and how it has resulted in certain situations where nobody is able to decide whether it is right, whether it is wrong. I told you that this 4-generation rights comprise of 2 categories, somatic rights and digital information rights. Somatic rights, I told you, includes the right to change sex. This case is a very interesting case. In R. J.K. versus Registrar General, decided by the Queen Bench decision, Administrative Court of London, the person who came to court was born a male. He married a woman in 2007. In 2012, the couple had a biological child. In the birth certificate of the child, naturally, the Registrar General of Births for England and Wales recorded the name of the father, recorded the name of the mother. But unfortunately or fortunately, after the birth of the first child, the complainant before the court, the biological father, developed a desire to live as a woman. He consulted doctors and he was assessed with a gender identity disorder and a concomitant gender dysphoria. Therefore, the doctors suggested a course of feminizing hormone treatment, which required him to live 2 years as a woman before a referral for gender reassignment surgery. In the meantime, in this 2-year period, his wife again became pregnant and delivered a girl. Thereafter, this person changed his identity, and on September 15, 2012, after the birth of the second child, he wrote to the Registrar of Births asking the birth certificate of the first child to be changed so that his present name as a woman could be entered there. Now the Registrar General went crazy. He did not know what should be filled up in the column for father. It was already filled up as Mr. So-and-so in the column for father. Now it has to be changed as, it can't be changed as mother because there is a mother. The Registrar General said, nothing doing, I will not do it. The decision of the registrar was challenged before the administrative court on the ground that this decision not to enter his present name in the birth certificate of the first child was violative of Articles 18 and 14 of the European Convention on Human Rights. Article 6 of the Human Rights Act 1988, London, UK, made it unlawful for a public authority in the United Kingdom to act in a way that is incompatible with a convention right. Therefore, the court had to follow the European Convention on Human Rights. Article 8 of the European Convention on Human Rights guaranteed respect for private and family life. But the dilemma that the court faced was as to whether the element of right under Article 8 could be invoked by a parent to the detriment of a child. If the parent had a right to his or her identity, the child that was born also had a right. Therefore, the Queen's Bench held that in requiring a transsexual to disclose her previous gender and by not allowing a change to official document to show the individual's chosen gender, her private life, right to private life guaranteed under Article 8 was violated. But at the same time, the court held that the state's interference in cases of this nature was on the basis that the failure to reflect on a birth certificate the true position at birth with regard to parentage may interfere with the child's right. The court opined that if the birth certificates of children were altered, the same would interfere with the child's rights to have its fundamental identity recognized. Therefore, the court found an easy way out of the problem created by the fourth generation right, which is the right to be identified as Mr. or Miss or somebody else. I will tell you one more shocking case. How the fourth generation rights how science and technology have created. I don't know whether they have created fourth generation rights or they have actually created a lot of debate. The February 15, 2024 edition of the newspaper Guardian carried a news item. The Guardian newspaper carried a news item on February 15, 2024. I am just going to read it because I don't want to tell you this case with words supplied by me. I will just reproduce what Guardian said. I quote, "The man identified as PQ, as he cannot be named for legal reasons, and his partner JK had experienced fertility problems and were not able to afford IVF treatment. As a result, he agreed to mix his sperm with his father's, which was then injected into the woman. The arrangement led to the birth of a now 5-year-old boy. But once the local municipal council, Barnsley, became aware of the circumstances of the boy's conception, it launched a legal bid to determine his parentage. The authority moved the High Court in Sheffield to direct that DNA test should be carried out to determine whether the man was D's father. However, in a judgment delivered only a couple of days ago, this is what Guardian says, the High Court dismissed the application saying that the municipal council had no stake in the outcome. The court said the municipal council may wish to know who is D's biological father. D is the child, but it has no stake in the outcome of the application. A wish to uphold the public interest in maintaining accurate records of births does not confer a personal interest in the determination of such application. This is what the court said. But the judge could not get out of the moral dilemma that the case threw. Therefore, the judge observed, this is what the judge said. This boy is a unique child who would not exist but for the unusual arrangements made for his conception. But those arrangements have also created the potential for him to suffer emotional harm were he to learn of them. Without testing, his biological paternity remains uncertain, but there is a strong chance, to say the least, that the person he thinks is his grandfather is actually his biological father, and the person that he thinks is his father is his biological half-brother. This is a glaring example. People talk about human rights. Now, do you think, I will ask you a question. There are 3 characters involved, 4 characters involved in this case. The father, mother, grandfather, child. Whose human rights are advanced in this case and whose human rights have been affected in this case? Can you please tell me? Yes? Huh? Child and father, their human rights are affected. All right. How many of you agree that the human rights of child and father are affected? So many of you think that the human rights of child and father are affected. But I don't know how the rights of the father get affected, because the father was a consenting adult. Child is the only person whose consent was never taken because the arrangement came only for the existence of this child, protection of this child. Whose human rights stand upheld in this case? Can you tell me? Father's human rights. Why not mother? Mother also, they could not afford an IVF treatment. That is why both of them agreed, and the grandfather was a consenting party. I would request you to have a separate session among students for finding out whose human rights are advanced and whose human rights are affected by this case. I just wanted to provoke your thoughts by bringing to your notice what science and technology has started doing. Now let me move to the third part. The third part is about how science and technology have also impacted our existing rights. One of the rights which has become a huge casualty because of the digital and information rights, which fall under the fourth generation rights, is our right to privacy. All of us now talk about our right to privacy. But science and technology, which amplified our right to information, has also hugely impacted our right to privacy. When you buy a cell phone, the phone company knows where you are and when. If you use a discount card, your grocery and prescription purchases are recorded, profiled, and analyzed. Many new cars, do you know, have inbuilt devices that enable companies to track from afar details about your movements. Software and information companies can even generate graphical link analysis charts illustrating exactly how each person in a room is related to every other through jobs, roommates, family, and the like. Almost anyone can buy a dossier on you, including almost everything it takes to commit identity theft for nothing. Recently, a video was in circulation. I do not know how many of you have seen that video. A customer goes to a grocery shop. He buys some item. He goes to the cash counter and makes payment. The shopkeeper asks the customer, "Will you please tell me your code?" He tells the code. The moment the customer tells the code, the shopkeeper says, "Your name is so-and-so, your wife's name is so-and-so, you have 2 children, they go to the school, you have allergy to so-and-so, you have these ailments, last time you took treatment in this hospital for so-and-so, therefore you have to be careful when the winter comes." The customer gets perplexed and he asks the shopkeeper, "Yes, it's me, but how do you know?" The shopkeeper says, "Sorry, sir, I can't tell you, Data Protection Act." So this is where we have come. Almost all these companies know who you are, what you do. The moment you type something in Google search, you want to know the nearest shop where you can buy a chapel. Next time when you go to the Google search page, automatically it lists out the number of the advertisements of several shops selling chapels. How do they know that you want this item? In olden days, we used to have a very interesting poem. It says, "The lives of great men all remind us we can make our lives sublime, and departing, leave behind us footprints on the sands of time." It's a very famous poem, Footprints on the Sands of Time. 100 years ago, only great men left footprints on the sands of time. Today, every one of us leave footprints in the internet. Therefore, it is easy to track. I used to tell my colleagues, today, Google knows much more about you than your own wife knows. And you children, you must remember, Google knows you much better than your parents know you. In fact, your parents should consult Google before they want to do whatever they want to do with you. I will now tell you an interesting case that arose out of the invasion of this privacy, and that will complete the third part of my lecture, and with that, my lecture itself. This case is called RE and TU and RE versus Google Incorporation, Google LLC. What happened in this case was 3 articles were published in an online magazine which criticized the investment model implemented by one company in which the complainants' companies held shares. But what happened was, the articles also contained linkages to several items about these 2 persons who were complainants with the photographs on their thumbnail. Therefore, RE and TU, they don't publish the names of the complainants. They sued Google Incorporation on the ground that they had invaded the right to privacy of these persons. The applicants in the main proceedings requested Google Incorporation, as the controller of personal data, first to dereference the link to the articles at issue in the main proceedings from the list of search results. You must all know that when you go to Google homepage, you will find a box. Below the box, you will find 2 smaller boxes. One box contains the words Google search. The other box contains the words, I am feeling lucky. Have you ever typed, I am feeling lucky? I am feeling lucky. Don't think you will feel lucky. I am feeling lucky means if you type there, Google feels lucky because they can make money out of you. I always tell youngsters, all of us use Google search engine. Why do we do that? Because we get a lot of services free of cost, correct? Whatever article, thesis you want to write, whatever moot court you want to attend, you type something, you get information free of cost. But you must remember, in this world, especially the Westerners have a philosophy, no lunch is free. They say no lunch is free. Therefore, if somebody is offering you something free of cost, you must know that he is offering you for a cost to somebody else. Therefore, they wanted these 2 complainants in this case against Google LLC, wanted the references to be dereferenced, the links to be dereferenced. And they also wanted the thumbnails to be removed from the list of search results. They also claimed to have been victims of blackmail by Google LLC. Google refused to comply with the request, referring to the professional context in which the articles and photographs at issue in the main proceedings were set. And they also argued that we were not aware of the inaccuracy of the articles. Somebody has written an article, he has provided a link. If you go to those links, your thumbnail pictures always get displayed. We can't help it. But what happened was, when the case went to the first court, Ländergericht Köln, that's called a regional court, Cologne, Germany, the case was dismissed. The applicants appealed. Then the higher regional court, it also dismissed. Thereafter, they went to the Grand Chamber. When they went to the Grand Chamber thought that this case required some deeper analysis on the basis of certain European conventions. Therefore, the court called Federal Court of Justice decided to stay the proceedings and referred certain questions to the European Court of Justice for answer. The questions were, it will be a little confusing, but nevertheless, you must know how privacy has developed. Question number 1 was, is it compatible with the data subject's right to respect for private life and to the protection of personal data if within the context of weighing up of conflicting rights and interests arising from Articles 7, 8, 11 and 16 of the Charter, European Charter of Human Rights, within the scope of examination of his request for dereferencing brought against the data controller when the link, the dereferencing of which is requesting, leads to the content that includes factual claims and value judgments. The second question was how far thumbnails can be displayed. The European Court of Justice answered the first question saying that a search engine operator is required to accede to a request for delisting where a data subject has been able to provide relevant and sufficient evidence capable of substantiating his or her request that establishes the manifest inaccuracy of the information found in the referenced content, insofar as that inaccuracy is not minor in relation to that content. Insofar as the second question is concerned, the European Court of Justice said that the most important factor was the informative value of the image that was produced in the thumbnail. Additionally, whether any text displayed with the thumbnail is capable of casting light on the informative value of that photograph for the public. The argument of Google was that we spread information in public interest. The members of the public have a right to know what is what. Therefore, right to information and public interest far outweighs the personal interest of the right to privacy of the individual, was the argument of Google Incorporation. But European Court of Justice said you cannot go beyond a point. It said when you display a thumbnail which is capable of casting light on the informative value of that photograph for the public and consequently of influence the weighing up of the rights and the interest involved. Therefore, it said a careful balancing exercise for delisting requests of images in search results is required, and that the contribution to a debate of public interest is an essential factor to consider. Though public interest can play a vital role, though right to information can play a vital role, right to privacy cannot be affected unless the other right overrides the individual's right to privacy. Therefore, when we have arrived at the fourth generation rights, new rights have been created with the developments of science and technology, and at the same time, not only our old rights have been impaired, but the old values with which we have all grown up are also now challenged by these developments in science and technology. With these few words, I thank you very much for this opportunity. Thank you very much.
Can you moderate who wants them to come here?
Sure, sir. Sir, we are truly honored by your presence. Thank you for the thought-provoking lecture that beautifully bridged tradition and transformation values and vision. I hope we are all a little less hopeless now and our waist is a little more full. Sir, so now we will have a small interactive session. I request those of you who wish to ask a question to raise your hand and a microphone will be passed to you. Okay, so whoever has a question, you can come up here and put forth your questions.
Next 4 can come. Let me see if we have time. 2 girls also.
You can come here. Come here.
Namaskaram, sir. Can you tell us about the Pegasus case, which some people alleged the BJP government used to spy on some journalists and other people? Does it highlight you of the right to privacy of the persons? And whenever right to privacy and national security is concerned, which is in the upper hand, right to privacy or the national security?
See what?
I'm Shailen, the fourth year law student.
Okay.
Thank you, sir.
That issue is already settled by the court. That there was no basis for the contention. The court said there was no proof to show that they had hacked the phones or mails of people, because there was no proof. The court said, see, this has got a history. In 2013, a person who was working in NSA flew to Hong Kong with huge piles of classified files and said that NSA was snooping upon individuals to collect information. And that person was Snowden. So from then on, the world became aware of the snooping of citizens by deep states. And in fact, one of the interesting things when I talked about law and science, I should tell you, science wants evidence. Law can accept evidence only if it is fairly obtained. An evidence which is truth, if it is not obtained by fair means, law rejects it. Which means, are we in pursuit of truth? Truth as collected by fair means alone is admissible in evidence in law. But in science, whatever way you collect, truth is important. So what happened was, all governments throughout the world are alleged to be snooping on citizens. But now people have become aware of one fact, namely, there are 4 types of characters who snoop on every one of us. 1, the state. Number 2, service providers like Google, Facebook, etc. What do you do with them? Then the third, information providers. I should tell you, a lot of people provide Ayurvedic treatment, allopathic treatment, etc. When they provide that information free of cost, they also collect data on you. They snoop upon you. And there are hackers who not only hack you, but also make identity theft. Therefore, today the privacy is under threat from 4 different persons, not merely the state. If state does it, we pitch the claim at a higher level. But that Pegasus issue is now settled.
Thank you, sir.
Yes.
Good evening, Your Lordship. Your Lordship, I have 2 questions with regard to the topic, Your Lordship. Number 1, there is a clear interdependence between science, the technology part of science, with respect to human rights. But it can be understood in a way that when there is human rights, science has its duty to be obliged by. Since we have one person having the right, the other person has the duty to not violate their rights. So in that aspect, how it can be interdependent with respect to duty and right of the different spectrums of rights, Your Lordship. Number 2 is with regard to the compass algorithm that we initially dealt with, Your Lordship. In that, the person was detained later and the conviction was held. But considering that he was not given a right to properly be heard, that whether he will be convicted, he will be committing the crime repeatedly, but blindly following a science is also a violation of the person's individual's rights, Your Lordship. So this will be my question.
Yeah. Insofar as your first question is concerned, the duty, right, flex, and the I think science has nothing to do with your duty. See, the science and technology have impact upon right, but not upon duties, because duties are imposed by moral codes. Even constitutional fundamental duties, it is not enforceable. Therefore, it is a self-discipline. When you have self-discipline, science has nothing to do with this. But rights alone, your rights keep changing. You acquire new rights, you destroy old rights, your perception changes about what is right and what is wrong. This is how science impacts you. So that is my answer to the first question. Second question is about this Compass case. The judge followed a scientific formula to find out. See, a person who is at the risk of repeating the crime should be punished severely is what the law says. Logic says, law says. How to find out whether a person is likely to cause violations again and again? This formula helps. So he applied science. Whether it is right or wrong, unfortunately, he went up to the Supreme Court, it dismissed. His argument was not that science cannot help. His argument was the formula applied was based upon an algorithm. The way the algorithm works is kept a secret by the company which came up with this formula, because they have the patent rights. If that is the case, I cannot effectively defend myself against the proposal to give me an enhanced punishment. That argument was not accepted, unfortunately. So the debate has to still evolve.
Thank you, Lordship.
Sir, you partly answered my question, but once again, I'd like to pose it for clarity. Sir, in the case of Eric Hamas, you said the Compass software was utilized and they ruled that since he has a high risk of reoffending, he was punished. India in law says, unless he is committed an offense, you cannot punish him. And preventive detention law says only up to 12 months you can detain him at the max. Just because there is a possibility that he can commit it in future, would not his fundamental right under Article 14 and Article 21 be violated if it's an Indian case?
See, there is a distinction. There are two parts. Conviction is a separate part, punishment is a separate part. For convicting this Loomis, the judge did not apply any formula. He only went based upon evidence. He saw the evidence, he found him guilty, he convicted him. When it came to the question of sentencing him, the judge has got a discretion. See, most of the offenses are punishable with imprisonment up to a maximum term. Certain offenses, there is also a minimum term prescribed. Now, what the judge did was, I can sentence this man to imprisonment up to 6 years. Whether I should punish him for 1 year, 6 months, 2 years, 3 years, 6 years. I will apply this formula. He applied this formula. The difference between science and arts is, arts is normally on, presumptions and surmises. Science is based upon evidence. If you accept mathematics as science, if mathematical formula is a science, it has got precision. What do you say? Unfortunately, such a formula could not have been applied in India. But there is also one complaint about judges in India. The complaint is that there is no uniform sentencing policy in India. What is your answer? If there is no uniform sentencing policy in India, How can a uniform policy come? And uniform policy come only when a scientific method is applied. If a scientific method is applied, you are questioning the very basis of the science. This is the difficulty.
So one more question.
Yeah.
Good evening, Your Lordship. I do have a question as an extension with regards to in the case of Loomis versus State. Now, in that instant case, a scientific formula was used as a basis for which the accused was determined, or even the sentencing was done on the basis of the said principle. But now we know that artificial intelligence has been rampantly raising, even in India for that matter. And even recently in Punjab, there has been a crime tool that the crime department had developed in order to identify accused persons. Now, in the case of State versus Loomis, we knew that the basis for the identification or even the sentencing was a scientific formula. But in cases of artificial intelligence, we are not aware of the source code, and we are not aware of the basis on which the accused is identified. How would that crime tool be justified? But because ultimately it is going to be very useful for the crime department.
No, I think all of us get confused between three things. A scientific tool used in investigation is different. A scientific tool used by the court in finding a person guilty and convicting him is different. Loomis case is one which crossed both these stages. There was no doubt about the fact that a proper investigation was done. There was no doubt about the fact that his conviction was correct. Only for sentencing they used. The Compass company did not come up with a formula keeping Loomis as the target. Yes. It is a formula which can be applied across the board to all persons convicted. For some persons, the formula would throw a result that he is not likely to commit an offense second time, because it takes into account multiple factors. You just again go through the formula. It takes into account age at first offense. It takes into account the way in which it was committed, the weightage to be added. So the formula was not just created out of the blue. It had a scientific basis. But the fundamental question was, is it better to leave the human discretion to this scientific tool? You are talking about artificial intelligence. In what way artificial intelligence? Artificial intelligence also works on algorithms. How would you ensure that they come to the correct conclusion?
The point was that there was no basis for the
correct.
right? Yes.
That's the point. Yes.
Thank you.
Good afternoon, sir. Good afternoon, sir. Thanks for this opportunity. So my question is from the part of administration of criminal justice you spoke on. So do you think the administrative overreach, such as by the investigation agency and the police, are contributing majorly to the human rights violation or not?
Come again?
Do you think the administrative overreach, such as by the investigation agency and police, are contributing majorly to the human rights violations? Such as by the investigating agencies?
No, that is not administrative overreach. Administration is different from police. The police overreach. The problem is, in no country in the world, the system of police is perfect. You must all see, in the United States, they have a project called Innocence Project. If you access the files of the Innocence Project, you will know that nearly 40% of the convictions are based upon wrong prosecution. in a developed country. Police are also human beings. Therefore, there is no guarantee that humans do not err. If they err, then if they err in bringing an innocent, if they err in booking an innocent, they violate his rights. If they let off a real culprit, they violate the human rights of victims. This is something, in fact, in 1956, a book, somebody from England, the book bore a very interesting title, Verdict in Dispute. That Verdict in Dispute, which was published in 1956 in London, it took six very important criminal cases decided by the highest courts in England. 3 cases ended in convictions, 3 cases ended in acquittal. The book establishes that in 3 cases which resulted in conviction, innocent people were convicted. In 3 cases where there were acquittals, the criminals were let off. So it's a challenge throughout the world, not merely to our system. I should also tell you something. I talked about neuroscience to you. Neuroscience says you cannot rely upon your own memory. They say false memories can be planted. Neuroscience asks a very important question. How many of you drive cars? Show me how many of you drive scooter, car, etc.? Some vehicle, yes. I will ask you, how many of you have forgotten where you kept your car key or scooter key? And now I ask you, many of you have forgotten where you kept the car key or scooter key. Have any one of you forgotten how to drive the vehicle? If you have forgotten, you will not be here. Then neuroscience asks these questions. What is the difference between the memory which does not allow you to forget how to drive a vehicle and the memory which relates to where you kept the car key? So human system, by fatigue, by long deprivation of sleep, by repeatedly speaking to somebody, neuroscience says confession statements regarding crimes that were never committed can be recorded. So it is not police. There is, in the entire human thing, there is something. That is the problem.
One last.
Good afternoon, sir. My question is that people often assume that along with the definition of human rights, the science and technology's definition should also evolve. So do you think that the scientist community has a greater challenge not only towards technical, but also towards social and ethical?
See, the science is not concerned about ethical part of it, because science leaves it to the philosophers to decide what is right and what is wrong. The only focus of science is to unearth the truth. The truth may be palatable to you, not palatable to you. That is why I said the difference between law and science is evidence-based. You steal something and bring evidence, science will accept. Law will not accept. How did you get this evidence? It was stolen from my phone. I will not accept it. Science is always in pursuit of truth. But the problem is, truth evolves. What is true today for a scientist will be proved to be wrong tomorrow because it evolves. And they are open to it. Every scientist is happy. A scientist of today is happy if his theory is proved wrong tomorrow. Whereas a lawyer or a judge cannot be happy like that. Once you hang a man, tomorrow there is no course correction. Is it not?
Yes.
Therefore, we admit about our arbitrariness. We think we cannot allow our wrongs to affect human rights. Insofar as science is concerned, they are not concerned about human rights, they are not concerned about ethics, they are concerned about finding out the truth, which is also very important.
Thank you, sir. Thank you, sir, for that enriching interaction, sir. We will cherish your words of wisdom and look forward to applying them in our personal and professional lives. With this, we have come to the end of this enlightening lecture. To formally express our gratitude, I now invite Swaminathan K, final year BCom LLB Honours, to deliver the vote of thanks.
A very good evening to one and all present here. It's my privilege and honor to present the vote of thanks on behalf of School of Law, Shastra Deemd University. First and foremost, I extend my sincere gratitude to the chief guest of the event, Honorable Justice V. Ramasubramaniam, former judge of the Honorable Supreme Court and chairperson of the National Human Rights Commission, for gracing us with his presence and sharing his insights with such depth, grace, and humility on the intersection with science, technology, and human rights. Sir, your words today were not just intellectually stimulating, they were also deeply inspiring. Your insights have illuminated the profound and evolving relationship between technological advancement and safeguarding the human dignity. The clarity with which you connected constitutional values, legal principles, and ethical dimensions of emerging technologies has left a lasting impression on all of us. And your lordships, in a life full of less, I assure you that we have gained more through this lecture, your lordships. I place my utmost gratitude upon our revered Chancellor, respected Vice Chancellor, respected Registrar, respected Dean Planning and Development, and our Dean School of Law. Further extend my thanks to the Nani Palkhivala Trust for having confidence in us and allowing us to conduct the prestigious series of lectures. I extend my sincere gratitude to the auditorium staff, civil maintenance department, electrical maintenance, IT support, transportation department, print and electronic media, deans of all the other school, faculty members of School of Law, and the entire Shastra family, without whose support the success of the event wouldn't have been possible. I would also like to take this opportunity to thank the members of the Trichy and Tanjavur Bar. Last but not the least, on a personal note, we are extremely grateful for the tremendous enthusiasm, participation, and involvement of the audience and my student friends. Thank you all for attending the event, and we hope to keep the spirit of Nani Palkhivala ji alive by conducting more such events and contributing more to the legal field. Thank you.
Thank you, Swaminathan. As we draw the end to this meaningful gathering, I request everyone to rise for the national anthem.
It's our duty to sing, no?
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना Thank you all. Please take your seats.